The panel is entitled Legal and Regulatory Framework, Actions and Harmonization for Legal Certainty at the EU level regarding blockchain. So first of all, I'd like each panelist, starting at the end with Claire, to introduce yourself and the organization that you're associated with, please.
Hello, I'm Claire Pion and I work for ConsenSys. I don't know if you hear about ConsenSys. We started incubator, we also do consulting on blockchain. We make many things. And I work especially on regulatory and legal issues that we have on our project in France. I have a background in financial market law. I think that's all.
Peteris, Zilgalvis, Head of Unit for Digital Innovation and Blockchain in the Digital Single Market Directorate in DG CNECT in the European Commission, and also co-chair of the FinTech Task Force in the European Commission. And I have a background, my doctorate is in law, but more in way back in environmental technologies, but since then in other types of technologies.
Good morning, I'm Stephen McCarthy. I am the Chief Executive Officer of the newly set up Malta Digital Innovation Authority, and basically my background is I'm in the management, and I'm a certified public accountant by profession. Thank you.
Hello, thank you. You heard me before. I'm Nadia Filali. I'm head of blockchain and crypto active program at Caisse des dépôts, and I'm lead of LaBChain.
My name is Choné. I'm responsible for financial innovation at the ESMA, so it's the European Securities and Market Authority. I've been leading the work on the blockchain technology and crypto asset at ESMA, and prior to that I also worked on the crowdfunding advice that ESMA published a couple of years ago already. And my background is I've been working in the private sector in the asset management business and for a credit rating agency before.
Good morning, everyone. My name is Domitille Dessertine. I work at the AMF, so the French Securities Market Authority. I'm the head of the FinTech Innovation and Competitiveness Division, which has been particularly involved within the discussions around the ICO pact regime, as well as the intermediaries in crypto assets regimes.
Thank you, panelists. So blockchain has been identified by governments and corporations as powerful technology. And the question is now, how do we make sure that Europe will benefit from it and can be an attractive region for blockchain growth and projects? Now, for this specific panel, the questions, just so the panelists know, will be directed by myself to specific panelists based upon your topic areas of expertise. So I will start with the first question. The first question is for Peteris, Stefan, and Claire. What is the role of the legal and regulatory framework in the development of blockchain innovation in Europe? And why is legal certainty so important? And I'll start with Peteris.
Thank you very much. Well, I mean, this is an area which we could call the law of the decentralized digital technologies. We're moving from a space where the legislation was either created in the pre-digital era or was created looking at players like Google and Facebook and Amazon, etc., that were single entities with a single control over data. When you look at the new models enabled by blockchain, but I mean also in areas linking to 3D printing, robotics, machine learning, and so on, IoT, big data, they may be much more decentralized, which is, I mean, probably very much an opportunity for our economies and societies. We have probably two ways to approach dealing with them, because this does not mean that we want to give up in Europe consumer protection, investor protection, fundamental rights, but these values can probably actually be reinforced by this decentralized approach, potentially, rather than this being a detriment to them. One approach is especially applying the principles-based legislation to these new types of technologies or to the decentralization. I think, and now I can compliment the observatory, the excellent report on GDPR and blockchain is one of the steps in this direction. Where the legislation is more rules-based or more in detail than in principles, for instance, in the financial sector, there's a working group, which is another action of the FinTech Action Plan, looking at barriers to technological innovation in finance. In fact, it has its next meeting tomorrow, and a couple of us will be participating in that as observers from the digital single market side. And then you have the other approach, which can be complementary as well. And this is something, quoting my co-chair of the FinTech Task Force, Peter Kirstens from DG FISMA, in a recent report from discussions in the United States, a so-called Millennium Act, the way you had, you could say, for the internet in the United States for blockchain. So, I mean, this could be partially for areas like let's enable smart contracts, let's enable tokenization, let's not simply try to aggregate it to principles-based or amend existing rules-based legislation. There could be something like an approach anywhere where you have a monopoly way of registering transactions, saying there could be, and as I mentioned at the beginning, we don't regulate a technology and we try to be future-proofed. So you could say something like a decentralized, resilient, certified, cyber-secure system. We're still in search of such a perfect definition that has the principles of blockchain, DLT, hash graph, etc., without locking us into a technological model. And something like this could, again, open up for competition, without either being, let's say, a regulation on blockchain or simply being applying the existing regulatory framework. This would be, let's say, a pro-competition move. So, I mean, this is something that this meeting and other inputs are very much a part of it. Do we need something specific on making smart contracts, for instance, legally recognized across borders to prevent fragmentation? Or, on the other hand, a principle of better regulation in the Commission is always that we can do nothing, leave things to the market, leave things to the existing regulatory framework. Smart contracts are code. Sometimes they have legal force because of the way that they're written. Sometimes they don't. So this is, I mean, very much an open subject, and it's certainly not us, the civil servants, I said, that will take the final decision. It will be taken by the politicians, but this is very much part of a process. Another thing is the tokenization, and specifically from my point of view, it's the so-called utility tokens, the one that's not an investment vehicle, not a financial instrument. I mean, we'll be hearing from ESMA already today, and I think also later this year. Do we want to enable this more for decentralized systems to allow consumers, participants to participate, the secondary markets for that? And so that's where we are, and that's what we're thinking of. I mean, we will apply, in any case, the existing legislation principle-based. Do we need to do something more, and does it have to go as far as being a kind of Millennium Act for blockchain, or the very open questions, which will be coming up for the next College of Commissioners.
Stephen?
Okay. Basically, what I want to start with is that Malta, basically, we have done a legal framework, so we have done the regulation. And I want just to give an idea of the way how we dealt with it. And basically, we dealt with it that we didn't want to do regulation regarding cryptocurrencies or virtual financial assets. We wanted to make a point that we truly believe in blockchain technology, and it is not just virtual financial assets. And basically, we have done this by enacting 3 laws. We have enacted the law for the authority, which is the Malta Digital Innovation Authority. I think this is one of the first authorities, and it is unique in its sense, and it is unique, and the intention behind it was because the idea that blockchain, DLT, is equal to cryptocurrency, we wanted to go away from it. Blockchain has a lot of potential, And we literally set up the Malta Digital Innovation Authority, which caters for DLT, smart contracts, and blockchain, etc. I'm saying this because besides this law, we have enacted 2 other laws for technology arrangements and for the Virtual Financial Assets Act. And the Virtual Financial Assets Act is there, which is under the Malta Financial Services Authority. So basically, our authority is there to support, and I repeat, this is important, because everybody been telling me that, listen, you have the Malta Digital Innovation Authority, so virtual financial assets fall under your remit, etc. And the answer to that is no. In the case of virtual, that's why the law is separated. We have an authority, ITAs, and the virtual financial assets. In the case of virtual financial assets, they fall within the remit of the Malta Financial Services Authority, because we feel that Malta Financial Services Authority has the resources and the experience to deal with cryptocurrencies, ICOs, and exchanges. But where do we come in? We come in from the technology side. We know that the Malta Financial Services Authority obviously has the experience in finance and instruments and investments. However, it may not have the necessary requirements and resources in the case of this new technology. So the Malta Digital Innovation Authority focuses to support the Malta Financial Services Authority in the case of this new technology. We didn't want to overlap. So basically, if we're talking about virtual financial assets, the leading authority, as I said, is the MFSA, and it is the MFSA which will issue the certification. In our case, what we have done is that we have issued guidelines for a systems auditor, which is a pivotal position, and the MFSA will ask for an auditor's opinion. The requirements and the procedures are quite onerous because we wanted to make sure that at the end of the day, the audit opinion is something serious, and given the implications that platforms such as exchanges will have. But what we are doing is that we will give support to MFSA. Support to MFSA, that we make sure that the quality of the systems auditor is there and it remains there. And the requirements to become a systems auditor, as I said, would be quite onerous. In fact, we have also come up with the idea of having an enhanced audit, because we feel not all platforms and not all solutions require the same systems auditor. If we're talking about exchanges, if you have exchanges which deals in millions of euros, daily or monthly or weekly, whatever, it requires an enhanced audit. However, if there is a platform which caters or has a cap of, say, 5, 10 euros, etc., we do not feel that needs an enhanced audit. The big challenges that we have is not to stifle innovation. So on one part, we have the duty to come up with something serious, honest, to safeguard users, but on the other side, because let us put it this way, doing an enhanced audit at the end of the day to come up with something concrete, it's going to be costly. For an auditor to come up with an audit opinion in order to follow the requirements which we have put over there, it's going to come costly. And in the case of startup companies with new ideas, etc., we didn't want to stifle that. So although we started in this way, eventually we will come up with a review or systems auditor also for startup, where we feel that there is a limited or low risk. But as I said, that is in the case of virtual financial assets, and the virtual financial assets comes under MFSA. However, the law also states that in the case of other ITAs, there could be voluntary certification. So where there is no VFA, there could be voluntary certification. They can come directly to the MDIA in order to get certification. Now, these could be either in education and health, where an operator would like to have a certification of his ITA. in that particular case, then he can come directly to MDIA. And also the law leaves space. It is basically what we say, it is future-proof. We're not, the Malta Digital Innovation Authority does not focus only on DLT and smart contracts, although they are specifically stated in the law, but we also left for up-and-coming new technology. And this year was the year of blockchain, but next year will be the year of artificial intelligence and IoT. So basically, what we're doing this year is that we're following the footsteps of the legal framework which we have done in the case of blockchain, and we will follow the same path so that we will encompass also other new technology. And basically, that is the situation that we are at the moment. It is only just the beginning. We have done these 3 laws, but we are working on, which I'm sure in the panel now we will be discussing, but we are other also very important topics. It is just the first 3, but we're coming. For example, we're discussing, or probably will be launching very soon, the issue of legal personality. Given this technology, I'm a certified public accountant by profession. I'm used to management, board of directors, shareholders, etc. In this new technology, the scenario, the mindset has to change. You have developers, users, miners, etc. And we intend to issue a legal draft in order to cater for the legal personality. And it is only one step. There are other chapters which have to come. So, as I said, this is only the beginning. We are happy that we are seeing all other countries around us very proactive in this area, because we believe that this technology is a cross-border technology. So there is no point in only one country or few countries embracing this technology and giving the legal certainty which is needed. It has to be accompanied by legal framework, either through standardization, as the EU is presently working on, but at least we must have some common definitions and common standards by different countries in order for this technology to promote itself. Thank you.
Thank you. Claire, did you want me to let me repeat the question for everyone, actually. So Claire, just as a reminder, why is legal certainty so important?
So about legal certainty, I think it's normal to see when a new technology comes to wait a bit before regulating it, because we want to see what are the different use cases, and especially for blockchain, as it's decentralized, it changed a lot of it questioned a lot the way that the regulation are made, and it's normal to have a period of time where we wait and see and to understand better the subject. But I think legal certainty is the most essential thing for letting the ecosystem grow, and it's why I think it's very good that we're doing this kind of a workshop with the European Commission, what they're doing in Malta or also in France. Because if you don't have legal certainty, it's a very big hurdle for actors on the part, because who want to start a business, to start to use the technology, if they don't know if like in a year there will be suddenly a law saying it's forbidden, you cannot do that anymore. And also for the participants and the consumers, the clients who will use the technology, they want to know what are the rights and the obligations linked to the use of the technology. So I think the legal certainty is a base for letting grow the use of the technology. And of course, it's not easy to decide and to put in place, because it's very recent. Blockchain is very recent, and we don't know yet how it will turn. We already saw new kind of ICOs, new kind of tokens, new kind of contracts, new kind of blockchain create maybe not every day, but every year. and we should be careful also to not regulate too early for not blocking things. But I think probably there is a middle way, creating temporary regulation, sandboxes, many ways to create a legal framework, a legal certainty to allow the blockchain to develop and to at least try to develop the use case in a clear legal framework.
Thank you. For the next question, I will be asking Nadia, Domitille, and Stefan. And I will start with Nadia. The question is, what legal initiatives have already been implemented? What are examples of regulations that had a positive impact on the ecosystem? Nadia?
Thank you. I talked about it when I began this morning. In France, we have the example of Loi Sapin 2 that permit us to distribute SMEs, non-listed SME security on blockchain. And when we began to work on that, now I think 3 years ago, it was important for all the financial place in Paris to take this opportunity to work together. And what we do concretely on that, it's that we launch a company named LaBChain with BNP, Société Générale, Euronext, Euroclear, AFS in Netherlands, I forget someone, Caisse des dépôts, and AF2Z. And we have Thibaut de Maintenon, the CEO of LaBChain, in the room, and that we can work together on this new technology, make us work, I think, more quickly, and with a new view on our process, and this technology can make us more innovating, I think. So it was not very easy to work together because many of the participants are competitors, but we can say that today we have a first version of the working, and we think that it will going on live next year. And I think it's important to make the regulator and innovator working together. And I think with blockchain is something that happened today. It's not as easy that we can saw on Twitter or others, because there is some work, not only photos and tweets, but it could work. And we don't have to forget that innovation nearly always precedes the regulators. So it's important to develop a discussion between all of us on this subject. And I think also Claire said that it's a very new technology. So we have to work on what we will do with the technology, on use cases, and not think that we will regulate the technology or the infrastructure. We regulate the use cases, but not the infrastructure. And we have to prepare something, I think, that it, for the moment, difficult to imagine, that we are working on some initiative that are nearly the same, have the same working process that we know now, for example, in finance or supply chain or other things. It's not very different it's not the new model. And if you want to work really on blockchain, on the new model that can permit the blockchain, we have to change a little bit the mindset. And I think on that it will be more difficult. And for example, if you are working on the economy tokenization, we will not work only on how we can certificate something, a transaction on blockchain, but also we have to work on what are the labor impact, for example, because we will make some transaction between people without a platform, and can you consider that it's you pay someone to work and to make this transaction or not? There is some problem on tax, for example. We work on that on LaBChain on the VAT. How you can have a bill on the VAT if you are working with a minor, I think is the subject. So there is many things that we have to anticipate, but for that we have to change some of our reflexes.
Thank you, Nadia. And Domitille, I'll ask you the question as well.
Thank you. So, as Nadia said, I think we have many things in the pipe, but I wouldn't say that there is actually any legal framework that is today implemented. It takes some time to have, of course, some new laws passed. So Nadia mentioned about the order that is now being discussed around the possibility to issue and transfer non-listed assets on a DLT. So this is one side. We have, of course, a lot of discussions also around crypto assets, non-financial securities crypto assets with the PACT framework. This is all ongoing matters. It should be all these frameworks should be into force next year. But I think we'll discuss more these topics in depth in a couple of minutes. What I can say is that I can say a few words about what we've done at the AMF over the past, I would say, a year and a half on all these technologies. We've been very involved around all the working groups and the discussions with the players that have been held over the past month around the use of these technologies. I would say that the first topics was really how the DLT may improve, for instance, the financial markets post-trade infrastructure. Then we had all these discussions around the crypto assets that started, I would say, 15 or 16 months ago. So we started to work quite early on this issue at the MF from, I would say, two perspectives. Mainly from the ICO side, because we really believed that there was a case for Securities Markets Authority, to the extent that ICO in the end are fundraising operations that are targeted to the general public. So it was relatively clear for us that there was a need for regulatory intervention. So we had first quite a thorough legal analysis that translated into a public consultation that we issued last year in October. Basically, we were providing a legal analysis of the extent to which the instruments that are issued through an ICO may be qualified as a security under the current legal framework. So our conclusion was that in many instances, vast majority of the cases would not, these instruments would not fit within the existing categories. And so we were proposing way forwards for regulation. So we were proposing three, so whether to come up with some best practices, some sort of soft regulation, whether to extend the existing frameworks to capture this whole new environment, or to come up with a bespoke framework, which could be either mandatory or optional. And this last option, so the optional regime, bespoke regime for ICO, was the one that gathered, I would say, most respondents. We had more than 60% of the respondents to our consultation that were in favor of coming up with these bespoke regimes. And in parallel to that consultation, we had also a program that was called Unicorn, for Universal Node for ICO Research and Network, which was basically a program. It was also a pun, but basically the program was a call for project holders to come and see us so that we could better understand what was really behind these new operations and how this would articulate with the business models. In a few words, we wanted to know whether it was just I would say a trend and a way to have access to cheap and fast money, or whether there was actually something behind and potentially a new way to raise funding which could complement the traditional fundraising methods. So we met with more than 80 players, ICO projects over the past year. which was very interesting because we noticed that most of these projects actually were very diverse. They were covering a broad range of sectors. I wouldn't say that all of them didn't want to access cheap money. There was actually some projects that were interested in that operation because of the trend. But I would also say that there is something behind very interesting trend in our view, is the fact that most of the projects really see ICOs as a way to constitute and create a network of both consumers and investors. And this really goes, I would say, in the direction of the GAFAM models, the business models, where really you try to constitute a community. So we published a couple of weeks ago an economic study, which is available on our website, both in French and English, where we draw some conclusions of these 12 months of meetings with the players. We also give some figures, although I would say that it's always very difficult to have reliable figures in that environment. But what's interesting is that over the past few months, in France, we've had 15 operations that are now over, and they raised about 19 million euros. So just to give you an idea of the amount that it represents, it's still relatively modest with comparison with traditional ways of fundraising, such as IPOs or VC financing, but still it's growing and it's a very new phenomenon. So it's an interesting trend that we want to keep on studying. So that's homework for ICOs. We've also met with, I would say, the whole community around this crypto asset environment. So we've had more than 50 meetings with all the different players, with really the view to understand to what extent the technology was really changing the business model as compared to the traditional players. I think that's really the key central discussions around this whole environment. Peteris mentioned about the technology neutrality, the law and the regulation must have. This is a very important point, and I really think that this is something that on which there should be a debate around the blockchain technology, because that's really the notion that it questions to the extent that the technology itself may want or the claims to replace some part of the financial intermediaries. So it really questions this notion of technology neutrality, and this is something that clearly should be discussed at the European level. Thank you.
Thank you. And Stéphane?
Yes, I've already partly answered this question in my first intervention. However, I would like to, when you said about initiatives, I already said that we have set in 3 laws. And the second law, first one was the Autorité, and the second law regarding the ITAs and services. In the ITAs and services, we have introduced 2 very important key persons, which are the systems auditor, which I've already discussed, but we also have put in the technical administrator. And as I said, this is a new technology. When you come to sit down and write the guidelines from the Act itself, then you can start facing certain challenges. And one of them was with the technical administrator. So basically, we said, listen, we have a systems auditor, he comes in, he audits, and he leaves. So basically, the job of the systems auditor is to come in, review, and then leave. We said we will have 2 types of audits. One audit which will be for totally new platforms which are not being used, and then we also had a test 2, which would be platforms which are already in use, so that we could review and compare the output of this platform with the actual blueprint. But we also then had to put also a technical administrator. The technical administrator would be appointed on a full-time basis, and he would have the possibility and the knowledge of intervention. And this posed quite a challenge given this technology, because the law states, which we have enacted, states that the technical administrator should have the powers of intervention in case of breach of law. And in that particular case, when we're dealing with a public blockchain, we had a lot of questions, because in the case of public blockchain, it's not always doable. It's not always technically feasible. When you're dealing with ConsenSys, it's not so. Once the law states that, but in particular cases, then the technical administrator would not have the technical capability to literally, if there is a component which is breaching the law, not to switch it off, or what we refer to as the kill switch. So that is something which you have to have a mindset with this type of technology. It is in the we left it in the hands of, for example, of the Malta Financial Services Authority, whether to accept. So in this particular case, we had to be a little bit flexible on whether to accept or not these particular platforms. So if the MFSA says no, it is my intention and it is a requirement that there must be an intervention, a direct intervention, then that be it. It's the same when it comes to voluntary. When it comes to voluntary, it is our prerogative to decide. So basically, what we're saying here is that, in my opinion, this is just the beginning. I feel that this technology, as everybody agrees, it's in its infant stage, and as we go along, all of us, in my opinion, will improve. Will improve with the legal framework that we put in. Will improve with the safeguards that we will put in. But one has to keep in mind that this is in its initial stage. However, I would like to conclude in this that this is the way forward, in my opinion. I mean, we all believe in blockchain. Everybody believes in blockchain, and it is not the right move to leave it in an unregulated way. Let us put it this way. I mean, Malta has put regulation. It is better to have operators in a regulated framework than as a situation as it was, where there is absolutely no regulation. It's like a Wild West situation. So this is the way forward. But the fact that we're going to be meeting challenges given this type of technology and given its infant stage that it is shouldn't dishearten all of us in order to move forward and promote and embrace further this technology.
Thank you, Stefan. Anne, would you like to add anything to answer this question? The next one. Okay, sure. Thank you. So we have yet to hear from Anne, who will go next. Panelists, I would like to say that now that we've set the foundation for the questions, for the remaining questions, if you could keep your responses to about 3 minutes, because then we'll have time for the audience to ask questions. But Anne, you're welcome to have a bit more time than that. I'll go ahead and ask this next question as you haven't spoken yet. So this question will be directed to Anne and Peteris. What are the EU level laws and regulations that will be released in the coming months?
And actually I think it's a nice bridge with the previous question, because I think first of all, we need to bear in mind that this is, and again, this was said by other panelists already, but I think it's a very important point. This ecosystem is still very new and with evolving business models, and also there is a wide range of business models. Stefan mentioned open public blockchain. I think there's different ways to refer to them. So there are differences in the way the technology is organized. There are also different ways in which the intermediaries in this ecosystem are organized and are working. So we touched upon ICOs, crypto assets, again a wide range of crypto assets being issued, some close to exchange or payment type token, sometimes called utility tokens, and other closer to investment type tokens. So I think this creates specific challenges for regulators, and we're fully aware that the rules that we have not been designed with these innovations in mind. But that being said, I think we need to take a step back. And I think the first thing that we need to ask ourselves is, if we look at those business models, what they aim to achieve, the risk and potential benefit that they may bring, how do they fit with the rules that we have? So I think the first step is we need to bring clarity on how it maps to the existing rules, how the existing rules may apply to those activities, and where there may be gaps and issues in the rules that then we'll need to address. And this is exactly the work that we've been doing at ESMA, so on rules that are within our remit, so financial securities rules. And so the first thing for us was to look at whether some of these instruments and related activities could qualify as financial instruments and investment type activities. And again, this is what other regulators have been doing globally. So I think it's also important that we keep an eye on what's going on outside of Europe. And so for us, the key question, considering the framework that we have in Europe, is, can some of these instruments be qualified as MiFID financial instrument? And the answer is yes. In some cases, it can. Not to say that it is in most cases, but in some cases, it is. And then comes a tricky question, which is, okay, so they are financial instruments, they may qualify as MiFID instruments in Europe and in the different member states. So this means that the MiFID rules apply, that all the other set of financial rules that we have apply. And when we say that, of course, again, when we look at the details of the rules, we see that sometimes we don't know how to interpret the rules. And we also realize that sometimes some of the technical requirements that we have are not entirely suited to this new ecosystem. So again, we've been working on that with national competent authorities, so like the AMF in France, because they're responsible for supervising those activities, so they're closer to the market than we are. And so together we try to identify where exactly in the rules that we have questions and issues. And I think maybe the most challenging part is not about the issuance. So it's not about ICOs, because if you think about it, when you're talking about ICOs, the key issue is what disclosure requirements do you make available to investors? And on that, my personal view is that what we have with the prospectus directive makes sense. And you have some flexibility in the prospectus rules, which allow you to tailor it to the specific risk of the instrument that you're issuing. But then when it comes to the rest of the life cycle of the instrument, so you have the issuance, then you have the trading on secondary markets, then you have all the issues around the safekeeping, custody of those instruments. And there, I think we have important questions. The first one is, what is it, when we talk about custody, safekeeping issues in the traditional world, when we want to apply this to this new ecosystem, what does it mean? So what is it, a custody service for crypto assets? Is it the holding of private keys? And then this holding of private keys, which form can it take? And we know it can take various forms. You can have different levels of responsibility for the providers of those services. So I think we need to ask ourselves, how do we define those services? And again, because we have rules already about providers for those types of services. And again, I think because the risk will be very similar, there are requirements in the existing rules that would make absolutely good sense for those crypto assets. So this is the first question, I think, important one. We also have questions about the settlement. You know, all this settlement finality. How do you make sure that you have delivery versus payment, that everyone agrees on delivery versus payment, and that you know who's liable if something goes wrong? And then I think this comes back to the different business model that we have, public versus private blockchains. If we're talking about public blockchain, entirely public, I'm not sure. As a regulator, I would feel entirely comfortable with the way those systems work, because again, and I'm talking as a regulator, but also from an investor perspective, also from a market participant perspective, I want certainty when I'm trading, when I'm transferring ownership. So how will this work in a blockchain world? We have, so the industry is working on some responses on those issues, but I think we need to work together, and I think we still have question mark on certain of these aspects, especially in certain types of framework, so certain types of blockchain network, the way they're organized. These are just two examples that I wanted to highlight. There are many others. And then another question for us is, so what I've just discussed is when the current rules apply, so when they are financial instruments. But then comes the question when they are not financial instruments. So when legally speaking they do not qualify as financial instrument, then as regulators, do we think that there are material risks to consumers that we want to address? And is it for financial securities regulator to take the lead on this? So again, I think there are a number of questions. I think we also realize again that the business models are evolving. The technology is still pretty new. In terms of the risk, I think again we need to have this risk-based approach. We also see potential benefits in the technology. I'm sure you've seen that in the report on the blockchain technology that we issued more than a year ago. But I mean,
we're going to need to wrap up in just a minute. Oh, go ahead. Yeah, one more minute.
No, just to maybe to conclude on this one, that we'll share some recommendations on those issues with the European Commission, hopefully shortly now.
Thank you very much. Peteris, before we get to you, we do want to leave time for audience questions, and we have quite a few questions left. So if we could ask the panelists to do around a 2.5 minute response, and then we'll allow time for questions as well. Thank you.
So I'll try to be short. We're in a space of not publishing new legislation in the next couple of months, but rather applying, assessing, and doing. Applying, as you see from the GDPR and blockchain report, are issues, for instance, with smart contracts, like with Article 22, the first paragraph, the second paragraph, especially if it's not a legal contract. So, I mean, that's something to be broken up perhaps later today. And I know Michel Fink, one of the experts who may have already arrived or is arriving, has done some very interesting work on this. Secondly, on assessing, this is what I already mentioned, looking at the smart contracts, the tokenization, removing barriers to blockchain. And finally, doing, which I briefly mentioned today but didn't get into more, was that with the European Blockchain Partnership, with this RegTech and publication of audit documents and certification and notarization of diplomas, I mean, we're basically with the member states running a regulatory sandbox in areas where a blockchain is, of course, not prohibited, but was not foreseen for regulatory reporting, for publishing audit documents, or for notarization. With the member states, we're working through the actual implementation, which may require minor, perhaps procedural or even legislative tweaks in the regulatory reporting. doesn't seem to necessarily need it at all for publishing the audit documents, and may, especially in the future, which then goes into the next commission, require us to do special things in order to utilize smart contracts and perhaps to utilize tokens for the payment of e-government services by citizens. And then just on this, not to create alarm among our central banking community and others, I mean, we're looking at some sort of, digital euro perhaps that could be issued by commercial banks or potentially in the farther future by central banks on the blockchain. But so analyzing, applying, doing, and I hope to hear thoughts among others on Article 22 on the decision-making, the automated decision-making and smart contracts if you see issues there of the GDPR.
Thank you. Our next question will be for Nadia, Stefan, and Domitille. What are the specific use cases or industry sectors that need tailored policies, and which should be prioritized?
We talked a lot about financial industry, and I talked first about the law in France on the post market. But I think there is other thing on the subject, and I have some remark of that was said before. I think today it's difficult to have a point of view on not only on what is public chain and to allow us to see the thing differently. And I think we have to see the thing differently, and I'm very happy to hear Peteris on what we can do perhaps in the future with the money. Because we have to remember the story, and Banque de France was not a public bank, and Bank of England was not a public bank, but of the services of the citizen, and especially of the context in the world and in France, and not only in France. I think it's very important to don't forget the expectation of the population and that the world is changing. So I'm a little bit engaged on that, but I think it's very important. And so we have to work on the digital and legal trust. What's the value of transaction? What's the value of transaction with or not smart contract management? What's about electronic signature? We have some things of YEDAS, and we work on that at the last workshop, but it's important. What about certification, intellectual property, diploma, and other things? And if we work on that, we have to work on that also on public chain, and thinking not about Bitcoin and Ether and what we know today, but what can be happen after that, because we don't know the governance of what can be happen after that we know today. And for us, there is some opportunities also for the citizen and our collectivité, I don't know in English what collectivité territoriale. We are working on a program named Public Chain at Caisse des Dépôts to help the public sector to work on that. And what's about the taxation on the transaction? Perhaps we can imagine different form to take the taxation directly on the transaction if there is transaction on blockchain. And we can work also on evaluation of transparency of public aids. And for example, we have some reflection with I know Peteris like it, Région Bretagne on the subject. For example, we have some reflection about attribute of identity, and not only the national identity, but also you can have some attribute for other services and consumer services, and how to have one attribute that we can provide on the blockchain and share with others. And we know that in France, for example, if you want to work on that with banks, for the moment it's not allowed in France, but it's allowed in other countries in Europe. Belgium work on that and make it work. Luxembourg work on that and make it work. So I think we can work on this point. And there is all the subject of open democracy and electronic voting that we can work also on that. After, I think there is a point that we talk a bit on the subject, but we have some matter now when we work on blockchain. If we work in financial sector, on delivery versus payment, if we use a token in an infrastructure, how we can put it in euro or in other money, and we have to work more quickly on that if you want really that blockchain works on financial services. I think it's very important because today we have a real lock on the subject. And we have also perhaps to remove some tensions between blockchain and GDPR. I know that Michel, I think, is in the room, and we have a report on GDPR. Some said that a hash of personal data, it's a personal data. Others said that no, and really it's dependent if you are on numbers or alpha characters. So it's technical points, and I think that on all what we talk about, we have also to work very proximally with technical people, because you talk about what we can do on custody, and at Caisse des dépôts we are working on this point for a public establishment, and we really know that the point is technical, and it's not the same view that doing a custody for a security today. And the point of the responsibility that you talk about, it's an operational point more than their legal point, I think, because today the question is where you put your key, who manage your key, who manage the transaction. You can have a multi-sign between many people, and for that we have to really put the end inside the subject if you want to know how it will work.
Thank you. Stefan, I'll repeat the question as well for the audience. What are the specific use cases or industry sectors that need tailored policies?
And basically, to be very short, there are priorities would be identity, RegTech, supervisory technology. However, more than that, I feel that it is very important that at an EU level we have common terminology, and it would develop common definitions of so that we would do not have conflicts of understanding of what falls under financial instruments, what falls under VFA, etc., etc. There are many other priorities, as I said before. I mean, then once the legal certainty is embedded in the law, then there are other sectors like court procedure, like liability, which is a very important factor. So there are many other priorities, but more important than that, I feel that we should come up with common terminology, so that at least in this ever-changing technology, we have a common understanding of what is what between us.
Thank you. Just a little administrative question there. Thank you, Stefan. And Domitille?
Thank you. So I'll speak about the financial services area, considering the institution for which I work, but I'm sure there are many other potential developments for DLT that needs to be studied. But in terms of financial services, we think that there are two steps. The first one is the first priority is to regulate what is today not regulated, and we think that it's quite a broad range of the environment. So speaking of crypto assets in particular. And there we see two priorities: is to have first a framework for primary markets, so for crypto asset issuance, and second, a framework for secondary markets. And we think that both are needed in order to have a sound ecosystem. We also need to reflect upon the fight against frauds and scam, which are quite significant in that environment. And we think that there is some considerable investor protection issues in that environment. That is why we think that it's a priority to regulate, and if possible at the European level, considering the cross-border nature of that environment. But we need to find some flexible ways to regulate. As it was mentioned earlier, it's a very early stage for the DLT today. It's a very recent technology. We need for as regulators to build an expertise on that technology. We think we need also to be humble. Many questions will not be answered from the outset. But we think that we need to start to understand it and to have some expertise built in that area. And the second step would be then for financial instruments, and there we think that a discussion at the European level is needed, as was mentioned by Anne earlier. The question there is, I would say, even more important, because the stake is to find the appropriate balance really between the side effects that can potentially harm the financial sectors, the existing financial sector, but also the obstacles that exist today and that may prevent the testing phase of new technologies. So there is probably a balance that needs to be found between these two challenges, but this is something that must be done at the European level.
And Susan, if I can add, I will just add one object to this list, or maybe the new governance structure, what we call the decentralized autonomous organization, who I think may become a very important subject very soon and could be added to this list of fighting for subjects.
Thank you. So wonderful responses from our panelists. I've been asked to go to questions. So if the audience has any questions, Ludovic, did you want to help me out here? If you have any questions, you may direct it to the panel or to a specific person. Sir, any questions?
Hello, my name is Elena Galklev. I present Bank Vontobel in Switzerland. I'm here to learn a bit more about the initiatives at the European Union level. My question is related to the maybe an alternative to the euro. Is there any project which is a kind of a tokenization of euro? Thank you.
Okay, what we know about, and which might be, much more better explained by them, is that apparently Austria has commercial banks on the chain, which, in the same way that the commercial bank stands behind a digital transfer, would potentially stand behind that. There's quite a bit of analysis by the ECB, which is online, about the technological feasibility of having a digital euro directly produced by the central banks, but for reasons of the current structure of commercial banks, this is probably not going to come quickly because of the major changes. I said what we are considering, and it's exactly in this kind of regulatory sandbox approach. The first services that will be on the European blockchain services infrastructure do not require payment. They're regulatory reporting and publication of audit documents. As you get into public services delivered directly to citizens, you first of all need to implement EIDS in the cases where you would need secure identification, passport, electronic signature, and so on in regular life, or perhaps some kind of self-sovereign identity for other things that don't require this level of identification. And the other thing is, because we certainly can't mandate as the European Commission that suddenly all e-government services become free, in those cases where a government, a university, certification authority would require some kind of payment, someone has to pay. What we have in principle foreclosed is using kind of Bitcoin or Litecoin or things like that. So, I mean, cryptocurrencies would not be there. The intention would be to use a fiat currency. And now, as I say, this is this regulatory sandbox part. I mean, you can say just offhand, yes, a commercial bank then could be on the chain and could stand behind, let's say, the issuance of this. But it's more complicated than that. But that's the level of the discussion right now. The political legal decision is that we're the European Union, we use the euro. And now we have to look for regulatory, political, legal ways to be able to use it. And as I say, I think there's a lot of thinking underway at Caisse and other places. I don't know if Nadia or the AMF or others want to add on that.
We are working on that in LaBChain. So we do a POC on what could be a tokenization of euro, and we are in the end of our work today. So we will have a return of experience in few days of the subject, and we are looking also what are the conditions for stablecoin. And I agree with Peteris, it's not as easy as we can talk about, because there is some subject of monetary policy, for example. And if the monetary policy is not done by a public entity or a public bank, the rules could be not useful for all the citizens, and we will create something that it's not sovereign. So there is a subject on that. But it's a real subject if we want to work on the tokenization of economy or public services, because we will not work with 1,500 of tokens. So at the moment, it will have to have a consensus on this subject, I think. And in some countries, they are working on that, but not in Europe.
Thank you. And we have time for a few more questions.
Yeah, so maybe right before, we are not going to be able to answer all the questions. So if there are questions or recommendations that you want to lay down, you have this link right here, and this will be used after to see what were the main questions and the main topics that the audience wanted to address, and this will be used after for the report. So please use this, and we are going, of course, to ask direct questions right here, starting here.
Thank you very much. Francis Messent from Swift. I'm looking after regulatory affairs, but I have background in post-trade for securities. My question actually about the work that was done earlier in France. I think with Sapin 2, actually France was very well ahead in the usage of blockchain in financial instruments. And therefore, I'm kind of wondering what we see happening now with the ICOs and so forth, and the issues that we have around what exactly is a crypto custodian and so forth. And so in how far did those questions come up or not come up when the initiative with LiquidShare and the consortium that you were talking about earlier, Nadia, and how far were they addressed? Did they come up? Did you have those issues or not? Did anything, or was Sapin taking care of all these issues and so forth? So that's like to understand. There seems to be a discrepancy between that early initiative from 2016 and the more recent issues we're encountering, as were stated by the other panelists around the ideas.
If you allowed me to ask Thibaut to answer the question directly, because the CEO of LiquidShare is here. So, Ludovic,
yes,
can you bring the microphone to the man in blue in the end of the room? Thank you. Thank you, Ludovic.
Thank you for the question. I think there is two aspects of it. One is on the listed or unlisted side. I think when you are on the listed side, it's in one way very simple, because you are forced to go under a very heavy regulatory framework, which is basically MiFID and CSDR. So you might use the blockchain as you want, but then you will have blockchain to secure what you do, but in addition, you would have all this regulation on top of it. So all the question you're asking on that field is less relevant, because you still need the usual way of doing custody, the usual way of doing trading. Now, if you go on the side which is unlisted, then very much everything is open. I think the question here, there's a lot of reflection. If you look at custody, and there is plenty of provider looking at how you can safeguard keys and so on and so on. I think the difficulty is about the business case. When you go for unlisted, it's very hard to find a conduit or some place where to find a large number of issuer, a large number of that you can capture. So I think it's pretty much in the making, and I don't think we can already say, oh yes, there is a real way to do that. So we have plenty of discussion right now with various providers and trying to find solutions. So sorry, I can't be more precise, but it's still in the making, I would say.
Thank you. Is there any additional questions? Got a lot of questions. Oh, Simone? Oh, right here.
You mean the additional question to the question, or
Whichever you like.
just making sure.
Good morning. My name is Simona Sculpadior from Tilburg University. I'm an academic, and my background is in startup financing. So first, I have a question for Stefan. You mentioned several times that cooperation and transnational cooperation in this matter is important. But from my perspective, what Malta is actually engaging in is regulatory competition. So, which in first stages leads to rather fragmentation of legal regulation than harmonization. It may lead into harmonization in the later stages, but this is from my perspective, so if you could comment on that. And then second question, very short, to Domitille. You mentioned that as a regulator, you very closely cooperated with projects, with the ICO projects. Do you follow up on those projects? And if so, do you know how many of them actually has their product validated? Because for me, selling a token is not market validation of the business model, but rather how many people actually use the service or product that is in question. So if you follow up on the projects, and what are the results of this follow-up? Thank you very much.
Stefan?
Okay. One has to, from your question, one has to keep in mind that the fact that we have legislation now, okay, it doesn't mean that we decided to go this way today. This decision has been taken 2.5 years ago. So we had a good team of professionals, operators, etc., which started 2.5 years ago. Unfortunately, 2.5 years ago, when you speak about blockchain, there wasn't this atmosphere. We had a lot of negative, and everybody's telling us, listen, you're going into the dark, this is a bubble, but we had the Prime Minister who was adamant about it and decided 2.5 years ago to go that road. Once we have gone through that road now in these 2.5 years, things have changed drastically, even from the perception of many professionals. So we're seeing now professionals who used to tell us, listen, you're heading into the wrong direction, this is a bubble, as I said, etc. Now embracing, and some of them, which is good, even promoting blockchain technology. And we are in this stage. So basically, if we are in this situation because we took the decision 2.5 years ago, and unfortunately there wasn't this positive feedback which there is today. Having said that, we are open and still believe that we can contribute. I mean, we're not saying that what we have done would be the Bible of every legislation. We're willing to follow standards, as I said, regarding common terminology, etc. We're willing to go with the EU. We're willing to use and give our support, which we are doing, to be honest with you. We're giving our support in forums, etc., to give our experiences and how it could be used. And eventually, we would like that, not we would like, but we would also offer that if other countries, including the EU, finds that our legislation could be used to help and could be used as a blueprint for up-and-coming legislation. But with respect to competition, okay, we are in a state today that, yes, since operators do not have anywhere with a legal framework specifically on blockchain, and we have it, yes, I must admit that they're coming to Malta to set up. However, this will not be long. I mean, from what we're seeing, other countries will catch up and will do their legal framework, etc. So that's the situation.
Thank you, Stefan. And Domitille, the question on ICOs and if you're following up with them.
Sure. Well, actually, most of them are quite recent projects, and they have a roadmap that is quite long. So we do follow up with them, but it's not yet. I wouldn't have any statistic to provide you with around how many of them have already developed their product and the services. And in the end, I would say that it's not even our role as regulators. So today, we're not competent with regard to any of these operations, but tomorrow when we will provide some visa to them, it won't even be our role to certificate or validate the products that is developed after that. So this is actually a very important point to us. We will provide a visa guaranteeing that the operation, the fundraising operation, has been organized with certain guarantees that we will define in further details in our general regulation, but we won't give any opinion about the project itself, the business models, the service that is aimed to be developed. So it's really just about the fundraising operation where we see a role for us as Securities Market Authority. And I would say that it's quite the same in the traditional securities area when there is an IPO or other types of capital operations. We don't give any opinion about the company, but just we ensure that the operation is conducted in a proper way with adequate guarantees in place.
Thank you. That's going to conclude our question and answer time. Oh, I'm sorry, Nadia.
Sorry, I was looking at my phone and it's a little bit indirect what is it's happening on the National Assembly on Blockchain in France. That they just announced that we'll have to invest 500 million euros on blockchain in France. Working with BPI France and ANRT and what we name Programme d'Investissement d'Avenir. It was the announcement of this morning on the public financial law for 2020 and next year. So it was what we asked for 3 years ago when we were talking first in our first discussion with Peteris. If you remember that. We said that we want 500 euro for investment, 500 euro for research. So we have 500 euro for both, but in one country, I think it's very good news for today.
Well done. That's the way to just about conclude.
And making France a blockchain nation as well. So, I mean, while we speak here, so I'm about to put it on Twitter if anybody wants to retweet it while we're here in Paris.
History being made live here at the EU Blockchain Forum. Well, we could give a round of applause to our panelists, please. Thank you very much.